Conrail apparently thinks that it is about time American farmers and utility customers begin paying for that railroad's abortive conception of subsequent mismanagement. Let's try that one again. It is, however, subject to readjustment at the Interstate Commerce Commission if one of the rail partners can make a case that it is not getting a fair or adequate share. Although this arrangement has worked effectively for over a century, it will be radically disrupted by the surcharge and cancellation authority. Most of my colleagues are now fairly familiar with this section of the bill, and I need not describe its technicalities at length. The formula was developed by two of the nation's largest rail transportation companies, Conrail and Southern. It favors inefficient railroads with high operating costs, and as such, the surcharge becomes a reward for inefficiency, providing railroads like Conrail with a means of enhancing their revenues at the expense of prosperous carriers and all shippers. Conrail has lobbied for its passage with the threat that without surcharge authority, the price tag on its annual congressional bailout will be increasingly high. Conrail apparently thinks that it is about time American farmers and utility customers begin paying for that railroad's abortive conception and subsequent mismanagement. Let's do the congressional first, and then we'll do the 110 jury charge. All right, this is a 1:30 congressional record. Today is 8/5. Lyndon B. Johnson. Lyndon is Lyndon. Johnson, Johnsson. Harry Truman, Truman. Franklin Roosevelt, Roosevelt. White House, initial caps, United States. Kennedy, Kennedy. Dwight D. Eisenhower, Eisenhower. Dwight is Dwight. Vietnam, Lyndon B. Johnson. Stonewall, Texas, Stonewall. Okay. Okay, here we go. 1:30. The death of Lyndon B. Johnson has taken the last of the nation's former living presidents, barely a month after the passing of Harry Truman. Johnson will deeply be missed by political friends and foes alike. In a way, he was the most American of our presidents, a figure larger than life, embodying within himself all the fantastic energy of a sprawling and powerful nation. A son of a South Texas prairie, Johnson worked his way from humble beginnings through the many stages of political endeavor to assume the highest office in the land. And like the state which nurtured him, he was cast on a gigantic scale. The former president's career spanned the epoch of modern politics, from his early congressional service in the days of Franklin Roosevelt to his own White House tenure in the 60s. When he was majority leader in the United States Senate, stories abounded of his fabulous energy, ability to reconcile conflicting views, and aptitude for practical results. He was a worker for the causes in which he believed, and seldom has a legislative leader accomplished so much under a president of another party as did Johnson under Dwight D. Eisenhower. Perhaps the most memorable single moment in Johnson's career was his ascension to the presidency in the aftermath of the Kennedy assassination. At that time of national pain and confusion, the man from Texas provided the nation with a steady hand and effected a quiet but sure-footed transition. He was able to unite the country in an hour when healing leadership was needed, and that leadership was confirmed by an enormous margin in the election of 1964. Most assessments of Johnson's career will praise his domestic record while asserting that he foundered on the subject of Vietnam. While the record on both these topics can be read in various ways, we tend to think the verdict of history will be the reverse of current assessments. The domestic initiatives of the Johnson presidency indeed have already begun to be reevaluated. It was in his repeated statements that the nation must stand firm against the tide of communist aggression that Johnson came closest to striking to the core of historical reality in the 20th century. Lyndon Johnson was a big man who embodied within himself the many impulses that are American and whose life was itself a continuing chronicle of modern American statecraft. Our politics will be infinitely the poorer for his passing. Lyndon Baines Johnson became the 37th President of the United States against a background of national grief and shock, and left office in a time of strife and questioning of the things he stood for and the things he did. But history may prove to be a fairer judge and a more honest one than some contemporaries in whose eyes disillusionment with the recent past seems overwhelming. Born on a farm near Stonewall, Texas, he was also born to politics, his father and grandfather having served in the Texas state legislature. As a young man, he taught school and as a teacher learned much about how everyday Americans lived. In 1937, he won a vacancy in the United States House of Representatives, in which he was to serve 5 full terms. All right, next. This is a 120. Today is 8/5. Lyndon Baines Johnson. Members of Congress, Congressional Record. Nurse Training Act, initial caps. Federal. Okay, ready?
What speed are we practicing at?
120. This offense involves two separate and distinct crimes. We have what we call statutory crimes. That is the legislature or a governing body have written down, put in writing, prescribed conduct, meaning either you can do something or you cannot do something, or if you do something, you can do it a certain way. One of these offenses is statutory and the other is common law. Common law means that it arose before the writing of the law. It is now in writing because of decisions through the course of history. The common law was brought to this country when the colonies were established. Larceny is a common law offense. There is a statute that governs larceny only insofar as punishment is concerned. The first is a statutory offense, and it is section 16-360 of our code. I will read the whole thing, and then I will just come back to it and comment on it. Whoever shall, A, break or attempt to break into any motor vehicle or any compartment thereof in the daytime or in the nighttime, with intent to steal the same or anything of value therefrom, or attached or annexed thereto, or used in connection therewith, or in the perpetration of any criminal offense, or B, break or attempt to break any tank or other vessel where kerosene or gasoline is stored, shall be guilty of a misdemeanor, and upon conviction, punishable by imprisonment on the public works of the county in which the offense is committed, or in the state penitentiary at hard labor for a term of not more than 5 years, or by a fine of not more than $1,000, either or both, in the discretion of the court. The first subdivision, Part A, relates to the offense charged in this indictment. It is whoever shall break or attempt to break into any motor vehicle or any compartment thereof in the daytime or in the nighttime, with intent to steal the same or anything of value therefrom, or attached or annexed thereto, or used in connection therewith. Now, the indictment itself says that the person broke into the vehicle itself with the intent to steal the same, and I tell you as a fact, there is no evidence that they attempted to steal the vehicle itself, the motor vehicle. If there is any evidence, it relates to entering the vehicle or entering a compartment of the vehicle with the intent to steal something from it. The first paragraph in the count as it relates to the automobile is, did break into an automobile of one Glover Motor Company, Inc., with intent to steal the same. The second paragraph, that Jake Wilson, Howard Salmon, and Van Hart did in Fulton County on or about the 5th day of July, break into the motor vehicle of one Glover Motor Company, Inc., with the intent to steal something of value therefrom. Larceny is distinct. It is a distinct offense. The first one charges breaking. The second one charges a larceny. Larceny is stealing. Larceny is the taking and carrying away of the goods of another with the intent to convert them to your own use and purpose. In other words, to deprive the owner permanently of those goods. Larceny is the felonious taking and carrying away of the personal goods of another with the intent to appropriate them to one's own purpose and use, to deprive the owner permanently of his property. It is petty larceny if the value is below $50. Otherwise, it is grand larceny. The elements of larceny are: there must be a taking because larceny involves a trespass against property. In order to constitute larceny, an entire possession of the goods, if for an instant only, is indispensable. There must be a carrying away. The carrying away, in order to constitute larceny, must be a removal of the goods from where they were, and the felon must, at least for an instant, be in the entire possession of the goods, and it must be the personal goods of another, and there must be an intent to appropriate the goods to the defendant's own use and to deprive the owner permanently of the property. Now, breaking does not have to be any descriptive thing. Breaking means that there is a barrier perhaps like land, an acre of bare land. You can be charged with trespassing on that land because you do not own it. Thus, you are breaking the barrier of the rights of privacy. To constitute a breaking, there must be some degree of force. If it would relate to a house, say, for instance, insofar as housebreaking is concerned, some force must be used to gain access to the interior. If a door is partly closed or closed, and in order to enter, you push the door open, you are breaking the protective shield of privacy. The same thing with a window. If you raise a window partly up, you have raised the window to gain access. If there is a mail slot on the door and you insert a coat hanger, maybe to hook something on the table inside, you are breaking and you are entering. There must be a breaking, either actual or constructive. There must be an entry, and at the time of the breaking and at the time of the entering, there must be, coupled with it in order to constitute the offense of breaking and entering an automobile, the intent to commit some other crime.
Okay.
Okay, here we go. Gentlemen, that concludes the testimony in the case and the able oral arguments of the attorneys. I will now charge you as to the law of the case. You have already gathered throughout the course of the trial that Mrs. Martha Tyler is the plaintiff, and whenever the term plaintiff is used, that is the one to whom we are referring. The defendants are the Thompsons, Mr. and Mrs. Thompson. This lawsuit commenced when the plaintiff, Mrs. Tyler, filed a complaint. That is the written pleading that I hold in my hand, and it is not evidence in the case. It is drafted by the attorneys and is a legal pleading. After Mrs. Tyler filed her complaint, she amended it once, as the law authorizes her to do, and that amendment is also a written document that I hold in my hand, labeled Amendment to Complaint. The amendment to the complaint had to do with the description of the land that is in controversy. In the complaint, the plaintiff, Mrs. Tyler, sues to recover possession of a tract of land. The amendment to the complaint sets out the description of that tract of land, the possession of which she is suing to recover. She claims, in addition to the possession of land, the sum of $2,500 for the detention of the land. Now, that is in substance the complaint of Mrs. Tyler. The defendants, Mr. and Mrs. Thompson, come into court through their attorney and file what is called a plea of not guilty. That is the yellow handwritten sheet that I hold in my hand, which is clamped to the complaint and the amended complaint. The plea of not guilty has the effect of stating by the defendants that the matters alleged by the plaintiff in her complaint are untrue. That is, the defendants deny the allegations of the plaintiff's complaint, except that by their plea of not guilty, the defendants, the Thompsons, admit that they are in possession of the disputed tract of land. Try that one again.
It's track and not track.
With the T.
Track, okay, that's what it's called.
Gentlemen, that concludes the testimony in the case and the able arguments of the attorneys. I will now charge you as to the law of the case. You have already gathered throughout the course of the trial that Mrs. Martha Tyler is the plaintiff, and whenever the term plaintiff is used, that is the one to whom we are referring. The defendants are the Thompsons, Mr. and Mrs. Thompson. This lawsuit commenced when the plaintiff, Mrs. Tyler, filed a complaint. That is the written pleading that I hold in my hand, and it is not evidence in the case. It is drafted by the attorneys and is a legal pleading. Mrs. Tyler filed her complaint, she amended it once as the law authorizes her to do, and that amendment is also a written document that I hold in my hand labeled Amendment to Complaint. The amendment to the complaint had to do with the description of the land that is in controversy. In the complaint, the plaintiff, Mrs. Tyler, sues to recover possession of a tract of land. The amendment to the complaint sets out the description of that tract of land, the possession of which she is suing to recover. She claims, in addition to the possession of land, the sum of $2,500 for the detention of the land. Now, that is in substance the complaint of Mrs. Tyler. The defendants, Mr. and Mrs. Thompson, come into court through their attorney and file what is called a plea of not guilty. That is the yellow handwritten sheet that I hold in my hand, which is clamped to the complaint and the amended complaint. The plea of not guilty has the effect of stating by the defendants that the matters alleged by the plaintiff in her complaint are untrue. That is, the defendants deny the allegations of the plaintiff's complaint, except that by their plea of not guilty, the defendants, the Thompsons, admit that they are in possession of the disputed tract of land. The legal effect of this plea is that it permits the defendants to introduce evidence of any fact tending to defeat the plaintiff's title and introduce evidence of any